Good afternoon. Be seated, please. We have two cases on our calendar for the afternoon. We'll hear the cases in the order in which they appear on the calendar. The first is Stallworth versus Finney. Is counsel for the appellant ready to proceed?
I am, Your Honor. May it please the court, my name is Major Harding, and I would like to introduce to you Ken Abel, my co-counsel in this matter. We are here asking you to reverse what is entitled an order on emergency hearing that modified a prior custodial order in effect, and that order was entered, we claim, without a pleading to do so, notice that it would be considered, and without a hearing. The husband has conceded error by the trial court. The wife previously filed a motion to enforce the final judgment and noticed it for hearing. She did this because the husband had indicated he was not going to comply with the current custodial order in regard to the schooling of their child. At the hearing, the trial court came to the room, announced that he did not decide issues regarding schools, religion, or doctors, and left. Because school was about to end, and this was in August, the wife filed a motion for contempt, to show cause, and for an expedited hearing. However, before that motion was even noticed for a hearing, the order that we appeal today was entered. The court denied the wife's motion for contempt with the statement that this, once again, the court does not decide issues in family law concerning schools, religion, or doctors, and urged the parties to agree on the matter, but concluded that if the parties cannot come to an agreement, the primary custodial parent will make the final decision. There was no motion by the husband to modify or change the arrangement contained in the custodial order, nor was there any notice that such a modification would be considered, nor was there even a hearing. And if it could get worse, the order is based on factual assumptions that are refuted by the record and for which no testimony or evidence was received. Opposing counsel, as I indicated earlier, has conceded the trial court erred, but claims that that error is harmless. He claims it's harmless because there were volumes of records and that the court had a broad knowledge of the parties. There's nothing in this record or in this order to indicate that the court considered any of those volumes of record, nor is there anything to indicate the truth, and that is that this is the first time these parties had appeared before this judge. To say that a court can amend a prior order or a judgment without a pleading to do so, a notice that it would be considered, and without a hearing being granted and evidence received, in effect to say that you can deny one the constitutional rights of notice and a hearing and say that that is harmless error is certainly bizarre, if not ludicrous. Unfortunately, the school year is now half over. The husband is in violation of the custodial order. The parties have incurred significant expenses because of the court's ruling, and certainly the error affected substantial rights previously established by the court, and violation of due process and substantial rights we claim are not harmless.
Is it next year under the order that he will have the right to determine the child's
when the child goes to middle school, and that child is in the 5th grade this year.
So, and I'm sure you know the reason I'm asking the question, is there any consequence of this appeal? In other words, what remedy could be imposed now? I'm struggling with that a little bit.
We would hope that the court would enter a speedy ruling reversing this order and directing the trial court to comply with the previous custodial order.
Oh, so maybe I misunderstood. There is still time left in this school year for this.
The school's not over until the end of May. Interestingly enough, judges, I have gone through the cases cited by my opposing counsel in the answer brief. Despite his arguments in his briefs espousing general principles of law, he cites no case that supports a modification of a prior judgment without notice, without a hearing, without evidence to support it. And just go through the index of the cases. The Cruz case, the opinion refers to evidence given. The Circle Finance talks about testimony that has been received. Gutierrez, testimony. Hancock, the evidence revealed. Kasdorf, the record supports. Martinez talks about an evidentiary hearing. Tamari, evidence failed to support. Snyder, the evidence in this case. And Munnerling, after conducting a hearing, and they talked about the undisputed evidence. Because of the stresses often created in family law cases, parties are often deprived of the stability that they would like in many areas of their lives. And certainly they would be able to look to the court and should be able to look to the court to provide some degree of certainty and stability. Unfortunately, that did not happen here. And we ask you please to reverse the trial court order and direct the court to enforce a prior custodial order. And in light of the statements made by the trial judge that he did not do schools, religion, or doctors, the court may wish to consider remanding this back to another judge for further proceedings. And I will reserve the rest of my time for rebuttal.
Thank you, Mr. Hardy. We'll reserve the balance of your time.
May it please the court. My name is John Kenny, and I represent Richard Shane Finney, the appellee and former husband in this particular cause. As the former wife's counsel has indicated, there are really two issues or two orders which are important in this particular case. First order generates from August of 2003 by Judge Cooper. The second order is the order on appeal from Judge Crusoe of August of 2006. The August 2003 order originally modified a shared parental responsibility between the parties, established that rather than a rotating parenting arrangement, which had been the practice for the parties since their dissolution, primary residency was awarded to the former husband, secondary parenting was awarded to the former wife, and a secondary parenting arrangement was allocated as far as time: weekend time, holiday time, and summertime. Specifically, Judge Crusoe adopted the findings, Judge Cooper in 2003 adopted the findings of Dr. Janice Tice and the agreement of the parties, which provided that the father, former husband, when Chip Finney entered into high school, would have unilateral decision-making authority with respect to him, and that he would have unilateral decision-making authority with respect to Michaela Finney, the only child subject to this appeal, likewise when she got through with elementary school.
But she's not.
She is not, Your Honor. That is
So
correct.
at this point, he does not.
Correct, Judge. He does not. And what I would
Well,
argue...
you're talking about some right he has in the future, but this case has to do with the right that he has now, which is not the right to determine this female child's schooling. Is that correct?
Well, Judge, it's under shared parental responsibility. What I think that the 2003 order indicates is that the parties are to, as you're required under shared parental responsibility, communicate and discuss where the children will go to school. In the event you have a disagreement, a court can, under Section 61.132B2A, decide that one parent will have that ultimate decision-making authority.
But the trial court in 2003 decided whether this child was going to go to school through elementary school. I mean, that wasn't anything that was subject to specific parental decision-making. I mean, they're going to have to modify, or that child's going to go to this school where they agreed the child was going to go to through elementary school.
Yes and no, Your Honor. I would agree with you that the court did indicate that she, Michaela, would continue through North Florida Christian. Where I would take the disagreement, and is where I take the disagreement with former wife, is that the parties are required to modify. That is not what is required. And in fact, that's the pivotal crux here. Did Judge Caruso's order of August 2006 modify without a hearing, which I would concede is error, or did it clarify, which is what this court has previously in Fussell and previously in Brown versus Brown in 1992 indicated a court can. Just because...
File a motion to modify, to modify judgment, or make a formal request in the proceedings below to modify a modified judgment.
I'm sorry, Your Honor,
I did make a request in the proceedings below to modify the modified judgment, which directed the child to North Florida Christian.
In March of 2006, in early April, there was a petition for modification filed by the former husband. It related to the issue of child support. It did indicate in the petition for modification one of the reasons it had to modify is the former husband, who was obligated by previous court orders to bear the responsibility of this private Christian academy by himself, could no longer afford to do so. And he requested that that be modified in order for that to continue. At the end of the year, and I should say the former wife filed an answer denying the ability or denying the desire to help out with those causes, and further making any denial with respect to any of the allegations related to North Florida Christian other than that the child did attend there. And later, by June of 2006, the former husband had both sent a letter to the former wife and to former wife's counsel indicating he no longer agreed with the direction the school was going or the costs, and indicated he would like to change. And that
Well, I'm looking at this order that was entered in 2003, and paragraph 4 here on page 4, it says that the minor children shall remain in North Florida Christian for the 2003 school year. The minor child, Michaela, will continue at North Florida Christian until middle school.
correct, which would be the end of this year, Your Honor.
Well,
Again,
how could that be any clearer? I mean, there's nothing to clarify. I mean, either they're going to comply with the court order or they're not.
well, Judge, very similar to what happened in Fussell, if this court recalls, because it was decided by by the first DCA. In Fussell, what happened was you had a trial court that had issued an order that said the father was permitted unlimited telephonic contact, as well as unlimited access to come to the school. How could that be any less clear? He can go there any time. Subsequently, a motion was filed asking to restrict that time. The father cited to several cases from the fourth saying if you restrict it, you are modifying. What this court held is no. The rational, reasonable plan implemented by the trial court was a clarification, not a modification. It was taking a right he had.
Were the parties heard on that modification in that case?
I believe the answer is yes, Your Honor.
See, that's the big problem here is I think counsel for the wife is saying that you can't do this sort of thing unilaterally and without affording a right to a hearing.
Well, again, I think
they
that...
argue, and I'd ask you to address this, they argue that the modification or clarification or whatever you choose to call it assumes facts, where the parties were living, what the original trial judge must have meant, things such as that, without any evidence, without any opportunity to be heard on that evidence.
Well, I would be less than candid to tell you that it would be better in every situation not to have a full hearing. Of course it would. It'd be great if the parties in every situation could afford a court reporter to come before the court, and I'm sure your jobs would be a heck of a lot easier. But the reality is, as Schneider held, that there are times in children's lives that can neither wait on an agreement from parents or from a mediating decision of the judge, which is exactly why Schneider versus Schneider, a 2004 decision from the 4th DCA, said it's permissible for a trial court to grant one parent the ability to make unilateral decisions so long as they continue to comport with shared parental responsibility, which is what this judge said. You two go and talk about it. Martinez, which was this court's decision in 1990, said it is an error as a matter of law for a court to decide where children should go to school. It's the parent's responsibility. That's what Judge Caruso was saying. I'm not in the practice of deciding which specific school you're supposed to go to.
The problem is the court had already decided which school these children were going to. I mean,
But Judge,
that determination was made in 2003, and
yes, sir.
my understanding is that modification order was entered as a result of an agreement between these parties.
Correct, Judge. And with all due respect, if you take that position that a final judgment can never ever be modified or never ever be changed unless a modification applies, well then, Schneider, Hancock, Cruz, Kassadorf, and Fussell all should not apply.
Well, and in none of those cases was there a hearing.
I'm sorry, Judge?
And in none of those cases there was a hearing.
Well, no, sir. And that is correct. I mean, again, it would be better to have a hearing, but what I'm indicating is, first and foremost, as we argued in our brief, that the trial court did not create a modification. If there wasn't a modification, just a clarification, then it's not a fundamental denial of due process and therefore mandatory to have a hearing. It would be better, yes. It would be far better to hear the issues concerning both parties. But in this case, there is, as I cited in my brief, and I can tell the court since I've been representing him since 1999, 3 full-blown custody battles in the record, a volume that the court has the access to, the trial court. He reads the constant litigation. And in fact, his comment that morning, as commented by counsel for the former wife, as well as counsel for former husband, is that the constant embitterment and litigation between the parties is not in the best interest of the children. And that's cited by Schneider as well, saying it's important to keep out the litigation. And a trial court is invested with the duty to protect the children. And to do so, Judge Crusoe said, I'm not going to make this decision. You guys go and try to work it out. He didn't grant sole parental decision-making authority to the father right away, thus changing responsibility. He kept it within Chapter 61.13, 2B2A, and said, you all still have shared parental. You need to talk about it. You need to take into consideration the children's concerns. But if you guys can't agree, ultimately, I'm going to allow the primary residential
What's the question
parents
in the contempt, whether Judge Crusoe was going to make a decision about religion or schooling, or whether he was going to enforce the decision that had already been made about that by Judge Cooper?
Well,
I can understand why he wouldn't want to micromanage the lives of these parties.
Correct.
And I can understand why he was frustrated. But is the question whether he was going to decide that, or was he simply asked to enforce what had already been done?
He'd been asked by the former wife with a filing to enforce a judgment, but make clear, as I responded in my motion to strike, that the former wife was asking for one thing and one thing only: make these children attend North Florida Christian. Our response was, no. We don't want to go to North Florida Christian. We've made that clear, and we've tried to discuss it with former wife, and we've heard nothing.
But counsel,
Yes, sir.
the court in its order direct that the children will attend Pacific School, i.e. North Florida Christian in this case, until completing elementary school. What is the appropriate manner to amend that judgment?
Well, again, Judge, I apologize. What I would argue is, if your position is, as the former wife's position is, that you've got to prove a modification, then no final judgments would ever go through tweaking or clarifications, as this court and the Fourth DCA has held, this court in Fussell and this court in Brown has previously held. The appropriate remedy was for the parties to, as they should in shared parental responsibility, communicate. That was done by the former husband, as is reflected in the pleadings. He communicated to the former wife. He no longer agreed with the direction that the private Christian academy was going and could no longer afford to continue paying for it. No response was heard. He began to proceed to enroll into public school. Then
Shouldn't the former husband have filed an appropriate motion or pleading with the trial court requesting the court to modify the order which directed the child attend a Pacific school?
I believe that is one avenue that could have been taken, yes, Judge. But as Judge Padavato just pointed out, then you get in a situation which courts, which are already overwhelmed with family law cases, are now truly micromanaging. The whole point of shared parental responsibility and not putting every single issue in a final judgment or in an agreement is to say, y'all are grown adults. You have children. At some level, you have to communicate. And you need to get out there and talk about this, whether it's dealing with school, education, or travel. The point of Section 61.13 2B2A is to say, because, as Schneider pointed out, there are times when you simply don't have the luxury to wait for agreement from parents or a mediated decision from the judge, you have to have one parent decide. Indeed, in this case, when the former wife filed her motion on we had the hearing on August 4th, school was starting on August 8th. The judge on August 4th, both in the morning and in the afternoon, urged the parties go to mediation, take into consideration the wishes from the children, because I'm hearing that they want to go here and they want to go there. And if you can't agree, his ultimate decision on the 8th was, and if you can't agree, then the father is going to make this decision. So the emergency motion that was filed by the former wife on the 8th was the third request. Time was of the essence. And the judge made the decision, because he's vested with covering for the best interest of the children, that this embittered and protracted litigation would not be in their best interest, and said, you have shared parental responsibility, talk about it. If you can't agree, dad decides. I would submit to the court, the critical crux for your determination is, was it a modification or clarification? If it's a modification, there's no question a hearing should have been held. It's a violation of due process. If, in fact, it's a clarification, as this court has held...
I'm sorry.
That's quite all right.
I had a question I wanted to ask you. In March of '06, the husband petitioned for a modification, right?
In March of '06,
He was really trying to get out from under the obligation to send the younger child to North Florida Christian because he was having trouble paying the tuition.
that or seek assistance by the addition of additional support.
That petition, if I understand correctly, is still pending.
It is, Judge, both petitions and counter petitions.
So you tell me if this is right. I guess the husband just got tired of waiting for a court order on the thing he had asked the court to do and then just did it on his own.
Well, not just on his own, Your Honor. He did, it's not as if he unilaterally, without notice to the other side, just went ahead and enrolled. A letter was sent, an attempt to engage in communication. What is replete through the record is, and as both counsel I think would stipulate, is these folks can't agree on the time of day.
Well, and that's exactly why these folks asked the trial court back in 2003 to micromanage the relationship between themselves and their child. That's exactly why there's specific directive, a specific order in this modification order in 2003 as to where this child was going to attend school. Now, you know, obviously what you're saying about how parents should be adults and how they should work together and make decisions about the children, some people just don't.
Correct.
And these people obviously recognize that they just couldn't. Otherwise, I don't know why they would have requested a court order in 2003 as to where their children were going to be in school during successive school years. The question, though, it seems to me, is after they've agreed that they can agree, but they agree prospectively, they request a court order. The court order is just as clear as it can be as to where this child is supposed to be in school. Why then one party can unilaterally decide to recede from that is not a modification. I'm just having trouble following, Mr. Kenny.
With all due respect, Your Honor, again, I believe that anybody that has children understands they are not static individuals. They're dynamic. Things change. I see my time is up. May I answer your question?
Sure, you always have time to answer.
Thank you, Your Honor. This court, both from Fussell and from Brown and the Fourth, have repeatedly held there are times that you can clarify, interpret provisions for the best interest of the children. Not just because they are unclear, but because you're protecting the best interest of the children. If this court were to say, anytime you want to change a final judgment at all, it has to be a modification, I submit to Your Honor that, first of all, those line of cases needs to be out the window, and secondly, a few more final judgments and a few more modifications will not be granted.
I can't understand, though, how a trial judge can make a determination about what's in the best interest of the child when the trial judge doesn't hear any testimony about it.
It would always be better, Your Honor.
It seems to me it might be essential.
Yes, sir.
May it please the court, I regret that I cannot respond to Fussell or Brown. It is not listed in the brief, and I regret that I'm unable to do that. If you wish, I would be glad to submit additional argument. But I would just briefly say that due process to these litigants does not equate to micromanaging. There are case after case that have set out that if an order is to be changed, there must be a pleading that it be done, there must be notice that it will be considered, and there must be evidence to support a substantial change. In this case, the judge never heard anything. The only thing that he considered, evidently, if he considered anything, was pleadings signed by counsel. And we know that that is not evidence. His client requested a change in child support and did not request a change in anything regarding the 2000 order as it related, 2003 order as it related to school. We would urge that you reverse this, that you do it quickly, and that you refer it back to the court for consideration to comply with that order of 2003 and before another judge. Thank you.
Thank you. Thank you both.